Good morning, everyone. I want to welcome you to this edition of Macro Pro and Friends. I'm Diane Cohen, Vice President of Client Relations and the Educational Department here at Macro Pro. Macro Pro is a document retrieval company. We can secure records for you anywhere where the records are located, nationally or internationally for that matter. We secure records for your claims and litigated files. And in addition to that, we can subpoena records from one state to another. That's right. If you have a claim in one state, but you have records in another, Macro Pro can get those for you. There's only a few states where that is not possible, but when you need records, please think of Macro Pro. Today, I am joined by Mandy Farquhar, our National Sales Manager. Mandy, how are you?
Good. Thank you, Diane.
Well, I want to thank
you for this today.
Yes, well, I want to thank you so much for all of your help in getting this organized. Before you introduce our speakers, we have just a little bit of housekeeping to take care of, and then I'll turn it over to you.
Okay.
So first of all, today is 1 hour Florida CEU credit. So you will be receiving your certificate from GoToWebinar within probably 2 hours. You must be logged on with the link that they sent you in order for them to be able to record your time and attendance. So make sure that you're not just calling in because they cannot track your time at that point. Handouts are attached to this webinar, so please download them so you have them for future reference. And in addition to that, if you have questions for our speakers, there is a question portion, and you can in the control console. So please write your questions in there, and we will be happy to ask those questions of our experts. And then lastly, there'll be an encore performance of this at the Macro Pro YouTube channel. So be sure to look for that. Mandy, again, thank you so much for helping us today. Can you tell us a little bit about today's topic and who our speakers are?
Sure. Well, hello, Florida. I'm excited to participate in this webinar with Mark Popolizio and Sid Wong at ISO Claims Partners. We also have Jeremy Baldwin, the Florida Territory Manager, here today. Jeremy, I bet there are a lot of new things going on and laws and procedures taking place in the last year with the CRC recovery, Treasury claims, and Medicare Advantage, right?
Yeah, thanks very much, Mandy. You are so right. There's been a lot going on in the world of Medicare secondary payer compliance, so we're excited to be here today.
Yes. Jeremy, do you want to introduce our speakers for today?
Yeah, thanks so much, Mandy. Really appreciate it. We're so happy for the invitation to join the session today. It's really great to be here. Hello, everybody. I am Jeremy Baldwin, and I am the account manager for Florida for ISO Claims Partners. I serve our clients by acting as a primary point of contact for Medicare compliance-related questions and for processing referrals. I also serve as the liaison between clients and our services team, and I work as a partner to review claims to find best fit solutions for those I serve. It's great to see so many familiar names attending today. For those of you I haven't met, I look forward to the opportunity to connect with you. And even more so, I can't wait until we are all back together again in person. So really looking forward to that. Okay, before I turn it over to the panel, please allow me just a brief moment to provide you with some background on ISO Claims Partners. We are the leading industry leader, I should say, in providing proven and cost-effective Medicare secondary payer compliance. Our client base includes 21 of the top 25 workers' compensation carriers and all of the top 10 P&C insurers in the country. We offer a full suite of solutions and services to improve claims outcomes, to keep you compliant, and on top of all of that, to save you money, whether it's Section 111 reporting, conditional payment recovery, MSAs or professional administration, or all of the above. You can trust our experience and expertise. Okay, thank you for allowing me to do that. There is a lot to cover today, so I would now like to introduce our ISO Claims Partners panel, who will be presenting. First, Mandy mentioned, we have Mark Popolizio, who is our Vice President of MSP Compliance. That's Medicare Secondary Payer Compliance, I should mention. You may know Mark from his Florida work comp and liability defense litigation days and his regular articles on Medicare issues. He's based out of Miami and has been knee-deep in Medicare compliance since 2001. He is a regularly featured presenter at national seminars and has authored numerous national articles addressing a litany of topics related to MSP. As a matter of fact, he just released 2 new articles and will have 1 more coming out on Section 111 reporting in an upcoming edition of the Florida Bar's 440 report. So be on the lookout for that. He will also be speaking again at the Florida WCI conference in Orlando coming up this December, and Mark and I are both excited and hope to see many of you there. With Mark today is Sid Wong, our Vice President of Policy. Many of you know Sid from his work with you on our referrals to us. He is a policy specialist and a true CMS trench warrior. He manages ISO Claims Partners policy team, where he helps evaluate the impact of MSP compliance on the industry and provides expert guidance to our customers. He also authors industry articles and teams up with Mark on webinars, such as he has today. He truly has vast knowledge in many areas involving CMS and Medicare, and I'm excited for you to have an opportunity to see that firsthand today. All right, I think that covers it. So, gentlemen, I know you have a lot on the agenda for our group. So, Mark, please take it away.
Thank you very much, Jeremy. Good afternoon, everybody. Live here from Miami. I want to thank Macro Pro, Diane, and Mandy again for allowing us to participate. And boy, we really enjoy working with Macro Pro. If you have not worked with them, give them a holler, learn about who they are. They're really great at what they do, and they're really nice people also. And this is our third or fourth event that we've done together with Macro Pro, and the other 3 or 4, Sid has shown up with a jacket. Today he doesn't show up with a jacket. I put one on, so to go back and look at the other session, one of us will have a jacket on, one won't. Today, Sid, it's you who does it. So thanks for messing me up. Okay, so our topic today here is Medicare triple whammy. Boy, this is a popular session, man. I submit this out. People want this all the time. I think the word whammy brings them in. We're going to talk about CMS recovery claims, Treasury claims, and Medicare Advantage, right? You and I like to call these things liens, but they're not technically liens, right? So here's our focus today. How does CMS's recovery process work? What are the current issues? What steps should you be thinking about to combat CMS recovery claims? You're going to hear about a lot of that today from Sid. Sid knows it inside and out from like the trench. He's been involved with the files, etc. We'll also talk about U.S. Department of Treasury actions. Sid is very experienced also there. What happens when Treasury gets involved? How do they get involved? When do they get involved? Or what can you do? Sid will guide us through that. I'll talk a lot towards the end about where we are with Medicare Advantage Plans. And here in Florida, we got action, right? So I'll educate a little bit on that. And sort of a bonus coverage because it's sort of tied to Medicare Advantage. I'll give you a little dose of the PAID Act, okay, which is ricocheting up the Billboard Hot 100 charts come in the next couple of months. So I'll bring you the latest on that. Okay, so Sid, let's move forward. Sid runs the boards here. He's multi-talented. Let me do a Medicare level set really quick for you. Let's lay the land out a little bit, okay, so this makes more sense. Go ahead, Sid. Let's move it ahead. So just like I did when I was in practice, right? Red flags. You know, how do we know when our claimants are on Medicare? Well, age, 65 years or older, Social Security disability, and workers' comp, for instance, that's a major deal. And we're not just concentrating today on comp. Today's portion, when we deal with these recovery claims, we're going across the board, and especially when Sid takes over, we'll split those atoms where necessary between comp and no-fault liability. End-stage renal disease is another way you get on Medicare, ALS, Lou Gehrig. So to the left are red flags. Now, once a person is eligible for Medicare, qualifies, he or she must make a decision on the right-hand side of this box, right, of this chart. And they have to decide whether they want their Medicare through the government program, traditional Medicare A and B. You'll hear Sid talk a lot about that today. When Sid takes over, he's going to be talking about recovery in governmental, traditional Medicare A and B, etc. When I take over and talk about recovery claims, I will talk about Medicare Advantage, okay, Part C of the Medicare program. We probably won't say too much about Part D today. That's prescription drugs. Those folks have not been all that active in recovery claims, so probably not much on that today. So that's the lay of the land there. As we continue with the background, Sid, let's move to the next slide. Here is Medicare secondary payer compliance in the big picture. Let's understand where we are today, right? The way you see these bubbles on the screen is seriously how simple Medicare secondary compliance is. Now, it's tricky and it's off the rails to a large part and with respect to how CMS administers the program, right? Okay, but we know about the Section 111 reporting, right, where insurers have to report claims electronically to Medicare that involve Medicare beneficiaries. Not too much on that today. I'm going to say a couple things to set it up, okay, where we have to go in that little bubble just for a little bit, okay? We're going to talk a lot today about conditional payments, traditional Medicare Part A and B. Sid will walk us through CMS's process of recovery there and the things you have to worry about. I'll talk about Medicare Advantage recovery claims. What we're not going to dabble into today, and we have another session on this coming up. We haven't chosen the date. Will be Medicare set-asides for Florida. Okay, so we're going to be coming back. Okay, we're just to focus on Medicare set-asides. So if we move it ahead, when we talk about conditional payment recovery claim, technically the term is conditional payment, and we put a definition on the screen. It's not all that exciting. That's the best I can do to make this slide look good. All right, and if you want to know what it means by definition, the Medicare payment for services for which another payer is responsible. A comp carrier, a no-fault carrier, a liability carrier, maybe the claimant himself, okay, for any of the reasons set forth in the regulations related to workers' comp, liability, and no fault. We got a little spelling error there, okay? That's basically what it is. And the idea is that if Medicare pays for something, they're doing so conditionally on the basis that they will have the right to be paid back. So the payment is made conditionally. That doesn't mean all their payments they get paid back on. You may be able to challenge them. We'll talk about that in a little while. So we go forward a little bit. Here it is today, the bigger picture. The Part A and Part B is what Sid's about to talk about very shortly, conditional payment. CMS is involved there, the Centers for Medicare and Medicaid Services. They use these contractors Sid's going to talk about, and there's a little bit of a connection to the Section 111 reporting. And I'm going to flush that out for you in a minute. Got to know just a little bit for today's purposes on 111 so you can really appreciate what goes on with Part A and B, conditional payments in traditional Medicare. I'll do Part C, Medicare Advantage, and we'll learn when we get there. CMS has nothing to do with the recovery there. Okay, so when Sid is talking, keep in your mind it's A and B that he's talking about. Go ahead, let's go forward. And here's your little dose of 111 reporting. I got to do it because Sid will talk about this in a minute in terms of how it connects to conditional payments. We know underneath the 111 reporting system that insurers have to report certain claims to Medicare if the claimant is a Medicare beneficiary. And on the left, they use a query system. There's the data elements. We don't need to get too deep into that. But let's pretend that we used a query. We found out this claimant's on Medicare. Look at the big plus sign. The person's on Medicare, and we hit a reporting trigger. We got to report. So for today's purposes, just understand TPOC and ORM. It's going to come back and haunt us very short. In the 111 system, the case is reportable as a TPOC, total payment obligation to the claimant, if we have a settlement with a claimant who for greater than $750. I don't care what it is, comp, no fault, liability, it doesn't matter. If it's a settlement, judgment, award, or other payment, a TPOC, which I have as trigger 2 today, sometimes I mix them, today it's 2, okay, then a case gets reported. But it also will mean something in terms of how CMS goes about collecting their conditional payments. You'll see that in a minute. Also in 111, a claim could be reportable if the insurer has ongoing responsibility for medical. They assume responsibility for the injury or a condition. Now, where do we see that a lot? No fault, med pay, workers' comp. Okay, not so much in third party. But if you assume that obligation for medical, right, that is a reportable event in 111, and it will also trigger Medicare to start their process on the conditional payment. Sid was going to show how this works very shortly. TPOC, ORM, remember these are coming back shortly. Sid, move it ahead. Let me set you up just a little bit further. Okay, so what we want to do now is go into slide that should say Whammy number 1. Let's see. We may be frozen or, okay, didn't move on my end yet, but Whammy number 1 is conditional payment claims that deal with government Medicare. Person is on the Part A and or Part B program. They go out, they have some sort of claim, and they treat through the Medicare system. Maybe they shouldn't have, but they get their benefits, or they get at least a bill or two paid through Medicare. The question then becomes, well, what type of right does Medicare have with respect to these conditional payments? And when the slide moves, we will see that Medicare, the government in Part A and B, has very strong rights, okay? They can go after the party who makes the payment. That's the insurance carrier. They could go after the party who receives the payment. That is the claimant and or his or her lawyer. Okay, so CMS, the government, has this strong ability to go after multiple parties as part of the claim. And that's why no matter how contentious the case may be, you want to make sure you're dealing with these conditional payments. Now, what happens if you don't deal with a conditional payment, right? And what you'll see on the slide is that several negative potentialities could happen. One, CMS could assess interest on the debt if it's outstanding and late. Two, they could sue the insurance carriers for double damage. Three, they could also refer the claim to the U.S. Department of Treasury. And if the debt is late, that is one of their options. And they do it a lot because it's pretty simple for them. Okay, rather than suing people, or they could for double damages, they will refer it to Treasury and have Treasury pursue the debt. Now, Sid, are we having an issue with the slides, or is it just my computer?
I can hear you. I can hear you loud and clear. I am advancing my slides. I don't see you on camera anymore, so I'm not sure if it's my end or your end, to be honest with you. But
Okay.
I am.
But which slide are you on? Just so
I'm on the Medicare recovery rights, Part A and Part B, and you just went through the liabilities and risks.
Excellent. So the deck is moving on your end. So I will have you take it over from there and talk about the process that CMS has. We know they have big rights. How does it work?
Yeah, thanks, Mark. So, Mark did a great job kind of outlining the basics of conditional payment recovery. I'm going to do a little bit more of a deep dive here. And I think a really good place to start is to understand how Medicare actually doles out these duties, right? So they're not actually handling it by themselves. They've hired two separate contractors to handle conditional payment recovery. And you primarily, and as a result, you'd be dealing with either the Benefits Coordination and Recovery Center, otherwise known as the BCRC, or the Commercial Repayment Center, otherwise known as the CRC. And these are the contractors that help Medicare recover these claims, coordinate these benefits, and work through them. On the next slide here, you'll see how that actually breaks down. So if you're working on a workers' compensation claim or a no-fault claim, it's a good chance that you're really working with the CRC primarily. And the reason for that is because the CRC, and Mark already talked about this previously, how Section 111 reporting leads to and helps effectuate recovery on the conditional payment side. Well, the CRC is really driven off the OREM reporting. So when an entity or RRE reports OREM is yes, essentially signaling to Medicare that there's responsibility by them as a primary payer, and Medicare is therefore secondary, and that's when the CRC steps in and can try to recover. They utilize various types of correspondences to do that. I'm going to talk about that in a couple slides down the road, but just understand the CRC tied to OREM reporting typically handles no-fault workers' compensation claims, and they actually view the debtor as a carrier and self-insured. And that differs a little bit from how the BCRC typically handles things. So just keep that in mind. They also utilize a particular type of authorization in order to communicate and receive information back from Medicare. And they call it the letter of authority. Mark, it looks like you're back.
I'm back.
Yeah, so and the other thing about the CRC, and I mentioned the correspondences, is that their correspondences are especially with the conditional, they call it conditional payment notice, is really time sensitive. You need to respond that to within 30 days. So that's the CRC handling, right? And the BCRC, on the other side of the coin, primarily handles claims where TPOC is reported or settlement is reported. This can be done through Section 111 reporting. Sometimes it's done manually through, you know, the plaintiff's attorney or the defense attorney or the carrier themselves, providing to Medicare what they call a final settlement detail document to let Medicare know that there's a settlement, what that amount is, what the breakdown of the settlement is, and asking for you know, a final copy of the demand that Medicare may issue on a particular claim. The BCRC therefore handles primarily liability claims. In some cases, and I'll talk about again this in a little bit, they might handle a work comp claim or no fault claim where TPOC was reported and the CRC for whatever reason didn't collect, you know, all the dollars that might have been available there, and they actually see what we call a debtor switch, where Medicare, the CRC closes their recovery claim with, you know, with and against the carrier or the self-insured, and then once the BCRC receives notice of TPOC, they open up a separate claim to recover off that settlement, off the settlement amount, and will actually pursue the beneficiary as the debtor, right? So a couple differences between the contractors and how they actually recover. So keep these in mind as we talk through the process a little bit further. So I mentioned the authorizations, right? The letter of authority is the one that the CRC utilizes and requires in order to open a two-way communication. So they will actually not provide information back to an entity without the letter of authority and allow for that entity to, you know, communicate and make disputes back to, you know, regarding the claim itself. This does not require the claimant's authorization. Remember, I mentioned that the CRC looks at the carrier / self-insured as the debtor. As a result, the letter of authority is signed by that entity. The other type of authorization is called the proof of representation. Now, this is the form that the BCRC typically requires in order to communicate with them. This is primarily for liability claims, signed by the beneficiary, by the plaintiff or claimant beneficiary. And this is one that you do need the claimant's authorization in order for the BCRC to accept it. Has the same effect as the letter of authority with the CRC. It allows two-way communication, allows disputing charges, and you're able to receive information on the file. The last type of authorization is what they call the consent to release, typically used for the liability claims. It's a limited authorization form. It allows for you to obtain information on behalf of the beneficiary, but it doesn't allow you to dispute or represent, you know, the individual with respect to the conditional payment itself. So a little bit more of a limited use there. So just keep so we have LOA with the CRC, POR with the BCRC, and CTR for limited access. As far as the conditional payment letter types, I think this is important to understand and distinguish between these as well. You know, you might get a number of correspondences from Medicare, not necessarily sure what's important, what's not important, where there's a deadline that might be involved, and hopefully this slide here will help you know, the audience understand this a little bit further, right? So first and foremost, you have a conditional payment letter. You can receive this either from the CRC or the BCRC. You generally see this often from the BCRC. But basically what this is, it's a breakdown of what the charges are that Medicare is seeking to recover. It's not something that you actually need to pay right at that particular point. In fact, the letter itself will tell you not to pay. It's in the way I would describe it is it's notice of what Medicare is seeking recovery for. You still have an opportunity to review that letter, to dispute that letter, issue a dispute back to the particular contractor, indicating what's not related or why you wouldn't be responsible to pay for it, you know, through the conditional payment recovery process. But just understand, don't make payment directly to a conditional payment letter. The other type of letter is a conditional payment notice, otherwise known as the CPN. Again, both contractors may utilize it, but really this is the document that, or the letter type that the CRC will generally issue. This one is critical because there is a due date associated with it. There's 30 days to respond to conditional payment notice. Otherwise, the contractor would issue a demand upon the charges that they're asking for recovery on. But again, it has the same effect to a certain extent as a conditional payment letter. Is a notice of what Medicare is seeking to recover. it's an opportunity to dispute the charges, but the main difference is, again, is that there's a due date involved here, 30 days from the date of the letter. If it's not disputed within that time frame, again, contractor could issue would issue a demand after that. In some cases, they say that your opportunity to dispute is limited to those 30 days. Now, we find that that's not typically enforced, 100% by the contractors, but that's how they've indicated it in some cases. So again, due date involved there. And then the other type of letter is the demand letter. This is what Medicare is actually asking for reimbursement from. This is the letter that you actually make payment on. It can be triggered by the conditional payment notice. It can be triggered by a request for a demand. It can be triggered just by Section 111 reporting and the contractor getting notice of Section 111 reporting data such as TPOC, such as notice of settlement, judgment, or award to resolve the claim. So that particular document that you get does outline what is owed back. You still have an opportunity to dispute it, but just understand the clock starts to tick when that demand is issued. And there's some other consequences if it's not paid timely. And then in the context of the commercial repayment center, where there's continuing ORM, you may receive multiple demands. As long as ORM remains open and there's charges to recover, a demand may still issue. And then finally is the final demand, which is it's the document or the demand that after which it's resolved or paid or resolved, that the contractor would essentially close their claim there. So it should be the last correspondence from that particular contractor. But as we'll see, if you receive a final demand, it may not be the end of the story. And I'll talk about that in a second. So when we look at the conditional payment recovery process, some things I do want to mention, some things that we've been seeing, in 2020 through 2021, some of the trends and issues with the particular contractors. A lot of these has to do with the CRC, but some of them play across both contractors. But first and foremost, I mentioned how the contractors are heavily driven off the Section 111 data. This is critical. So if the Section 111 data is not reported accurately and that triggers recovery from the contractor and it's not corrected by the time that you make your dispute, the contractors have denied those disputes because it doesn't line up with the recovery data that's been reported through Section 111 reporting. Now, also keep in mind with civil money penalties been announced in February of 2020, not necessarily implemented or enacted yet, but just understand that one of the things that Medicare is looking at is when Section 111 data doesn't align with the reported with the disputes for conditional payment recovery, that's actually grounds for Medicare to issue a civil money penalty. So certainly something that the contractors are trying to get in line when handling these recovery claims. Also, we've seen that contractors are adhering strictly to dispute deadlines. I mentioned that the demand starts the clock, right? So if a demand is not responded to or disputed within 120 days from the issuance of the demand, it's considered untimely, and it can scuttle your opportunities to actually file for a successful dispute. So keep that in mind. And they're less willing to work on the back end with you to try to resolve things, even where the evidence is clear that it's not the responsibility of the primary payer to make payment for some of these charges. This has led to increased Treasury referrals. And I've already mentioned and discussed the TPOC settlement issue where the contractors may actually switch. So you might receive what I mentioned previously, a final demand from the CRC indicating they're closing their claim, but for whatever reason, there's still charges left over, perhaps because there's a denied component to a workers' compensation claim, for example, and you've been able to successfully dispute that with the CRC as a result. They accept your argument that it's a disputed body part and therefore you're not responsible for it. They close their recovery, and then later the BCRC gets notice of that settlement. There's still some charges left over for that disputed body part. They open a separate claim for recovery. They seek recovery for it, but they're not accepting that argument that the CRC accepted because they're just pursuing directly against the beneficiary, directly against the settlement. So there are some dynamics there. Our recommendation is to just be aware of that, make sure the parties are aware of that, and have a plan in place in the event that that happens. So when we're talking about challenging conditional payment claims, and I mentioned how we were able to informally deal with contractors in the past. You're able to argue, not necessarily have to file a formal reconsideration yet, but just say, hey, listen, we're disputing this. This doesn't look right, and here's why. again, the contractors haven't been as willing to work kind of in those back channels as much. You can still make that initial dispute, but if they disagree with that, they're really pushing you towards that formal 5-level administrative appeals process that you see on the screen there, right? Redetermination with the original contractor, reconsideration with the qualified independent contractor. Those are the 2 levels that we generally engage in, because you have you can typically get a response time within 60 to 65 days, depending on what the workload looks like. And then it starts to get more cumbersome, right? So you can file it then to an administrative law judge. Our experience, it could take a few years to actually receive a hearing date after filing for a request for an ALJ hearing, so just keep that in mind. And then if that's not successful, you can appeal further through the Medicare Appeals Council or federal court. But then, just keep in mind that you can't skip levels. Like, you can't just go straight to federal court. And Mark, do you want to talk about this a little bit? I know that there's some case law around that, but we know that some people want to jump that a little bit, but the courts have kind of dialed that back.
Yeah, and understandably, like Sid said, I mean, it's a torturous system, right? 3-4 years, you got to go through it, and I guess CMS wants to see, who really has the gumption to go do that. So what happens a lot in the cases is, especially with the lawyers, and Sid and I talked about this on a legal counsel webinar, and I'm not saying these are crazy ideas, not at all. Okay, where lawyers have tried to jump the levels, or for their clients, and go right to 5 and say, I'm not going to mess around with 2, 3, and 4. Who has time for that? I'm going right to federal court, and I'm going to make a number of arguments. And a lot of times they'll make constitutional arguments or et cetera. And the courts have been very protective, as Sid said, to the timelines and for the level. So there's this idea of having to exhaust administrative remedies. That's what you read in the case. And the courts a lot of times toss the cases out. You fail to exhaust administrative remedies. So it's important that you understand the level. And I think Sid mentioned it's important that you abide by the timeline, because if you miss the timeline, the courts are not very forgiving. There's cases too where the courts dismiss the insurers, or it could even be the claimant. The claimants appeal in one of these levels because they missed the timeline to file it within, the certain parameters. So that's what I would say there, Sid.
Yeah. Thanks, Mark. All right. So that wraps up the first section. We're going to move on to whammy number 2, right? Treasury. So we already talked about the contractors, how they operate, what type of authorizations, what type of letters you may get, and the time frame involved. And I also mentioned that we've also seen increased activity and referrals to the U.S. Department of Treasury for collection because of some of the things that have been happening at the contractor level. So on the screen here, I'm not going to spend a ton of time on this, but I think it's a good illustration of the timeline of which the conditional payment process moves along, right? So I mentioned that the demand is critical because it starts the clock, right? It's really important that once you get a demand, to take action on that, whether it's disputing or paying or trying to resolve it, because once that occurs, right, you have 60 days from that date of demand before it's considered overdue. And when that occurs, then interest starts to accrue on that, right? On day 61, interest actually accrues back to day 1. It starts on day 61, but it actually accrues back from the date of the initial demand letters. So interest will start to accrue. Interest is varied, right? It can change periodically, but it generally averages between 18 to 20% of the debt, right? So, not only interest, accrues, but also your opportunity to dispute, starts to tick by, right? So you have 120 days after the date of the demand to file your dispute. If it doesn't, then Medicare actually has the opportunity to refer that up to the Department of Treasury for collection. Once that happens, a couple things could happen, right? But the other thing too is that Medicare will issue what they call an intent to refer letter before they file it or before they escalate it up to Treasury for collection. In the past, it would give that to you probably about 100. Probably on day 60, around that time, we started to see Medicare, issue that, or the contractors issue that, sometimes weeks before that occurs. So there's not a lot of time to handle it. So just be aware, if you get that ITR letter, that's a red flag to say, all right, this is late. We need to jump on this. We need to take care of this, as quickly as possible. So, when it goes to Treasury, again, I mentioned a couple things can happen. First and foremost, they can forward that over to their offset program. If that occurs, they can offset dollars from something that might be owed back to the debtor through the federal government, or in some cases the state government. So if you see some money being taken away from a tax return, for example, that could be because of the offset. They could also forward it over to a private collection agency that will try to recover it, as Mark mentioned, also forward it to the U.S. Department of Justice if they choose to file a suit in federal court for collection. So, with that, again, keep in mind that everything that I've discussed so far has been about traditional Medicare. So one of the questions we often get is, what happens or how does this change if we're not dealing with the federal government, but instead dealing with Medicare Advantage plans and maybe a private insurance company? So Mark, why don't you take it from here and talk us through some of that?
Yeah, thank you, Sid. And that's right. So everything Sid talked about, we prefaced it by saying the claimant had his or her Medicare through the Part A and or Part B system, the governmental program, which is run directly by CMS. And what Sid discussed was the process that CMS had, all right? And, he did a fabulous job in some of the issues that you have to be aware of. Now I want to switch it when we talk about whammy number 3. Now let us pretend that we have a claimant who has their Medicare coverage, not through the governmental plan, but through a private Medicare plan called Medicare Advantage. So let's learn first on the next slide what these Medicare Advantage plans are. Oh, this is a lot easier, Sid, when you can see the slides. Okay. Well, these Medicare Advantage plans are private insurance plans. The government created Part C of the Medicare program, Medicare Advantage, about 23 years ago now, 1997, okay? And it only recently really took off in the last 10 years. And they did it on purpose to ask private industry to come in and help them with the program. And, part of it was to help them contain costs. Okay, we don't need to get into that today, how they do the bidding and stuff like that. But a big part of it was to provide the beneficiary with more options, open it up to the marketplace so there could be a lot of competition, okay? And if you look there in the middle bubble, we have over 3,200 different Medicare Advantage plans in the country, right? When we talk A and B, it's one plan, whether you're here in Miami or up in Long Island with Sid or out west with Mandy, okay? It's one plan if it's a governmental plan. When it's Medicare Advantage, lots of plans, right? And the folks really like these plans. Look at the bottom bubble. We have close to 40% of all Medicare beneficiaries in the country nationally now on a Medicare Advantage plan. There's lots of reasons for it. They like the plan. They typically offer more than regular Medicare, government A and B. Lots of advertising. Sid and I joke all the time about Joe Namath. In fact, I just saw him. I got TV on mute over here. He was just on. Right? This guy won a Super Bowl. I think for a guy, he's all juiced up about these Medicare Advantage plans. That's what he's talking about. Mike Ditka and Joan London and all these celebrities. Call the hotline. They want people to call the hotline. I'm not saying they're doing anything bad. They want people to call the hotline to try to get them into one of these Medicare Advantage plans, right? My dad had one for years. My mom's in one now. People like them. So take a look on the next screen. Check out the country, right? There it is. Look at Florida. It's red. Florida is one of 18 other states and Puerto Rico who have enrollment rates for Medicare Advantage greater than 40%. Florida's rate's 43%. So almost half the Medicare beneficiaries in Florida now have their Medicare through a Medicare Advantage program. So we got to pay attention to this. It doesn't matter what type of claim you got, right? You take the plaintiff or the claimant as you find them, right? Comp, liability, no fault. If the person's on Medicare, the next question should be, well, what type of Medicare? Now, the big question, well, first let's knock out who the players are, Sid, on the next slide. So the big players in the Medicare Advantage space are United Health, Humana, and Blue Cross. Okay, look, there's tons of other little carriers, but also understand like each one of these insurance carriers that are part of the Medicare Advantage system could have multiple plans underneath their umbrella. I don't know, but I'll make it up. Like United Health may have, I'll make it up, 200 different Medicare Advantage plans underneath their belt, right? Okay. And it was meant to be in this way. It was to give the beneficiary option. Okay. So these are the major players that you'll see on the block. Okay. So that brings us to the questions we really want to know in terms of claims. Do they have lien rights? Oh, I hate to use that word. Do they have recovery rights? If so, what's going on? How does it work? First of all, do these Medicare Advantage plans have some form of recovery right underneath their own statute? They have their own statutes and regs, Medicare Advantage statutes and regs. And the answer is yes, okay? You know, look, legally, you know, the word's a little bit wobbly here and there, but they got some type of right. How deep it is could be another story. But the bigger question is this, because you don't even have to worry about that. If the answer to the next question is yes, do the Medicare Advantage plans also have double damage rights to sue people and insurance carriers, right? We know the government does. I told you that. Sid told you that. They can do it. Whether they do it a lot is another question. They go to Treasury a lot because it's easier. Treasury just siphons the money through a Treasury offset. That's a lot easier than filing stuff in federal court. But the questions the Medicare Advantage plans have had to litigate for reasons I won't bore you with, right? Okay, maybe too late for that, okay? But they've had to litigate the question of whether or not they also have double damage rights. And you want to know, folks, they are winning. And in Florida, they're winning. Let's go to the next slide, Sid, okay? Study red and yellow states. Red states are U.S. Circuit Court of Appeal decisions. Yellow states are U.S. District Court decisions. Yellow a little bit lower. In the red and the yellow states, the courts have ruled that the Medicare Advantage plans can, C-A-N, sue insurers for double damages. Let's focus on Florida. The big case in Florida was 2016, Western Heritage and Humana. Okay, Humana was the Medicare Advantage plan. So what the 11th Circuit ruled was, number one, yes, the Medicare Advantage plans can sue for double damages. The statutes allow them to do that. And in that case, the facts were actually ripe enough for them to go further. And in that case, they said, and in this case, we are levying double damages against the insurer. We find that they did not properly and timely respond to Medicare Advantage Humana's lien, recovery claim. So we got to be careful about Medicare Advantage claims when we see them in Florida, because we have a very strong ruling that they can sue for double damages. There was also a second ruling last September where the court, the 11th Circuit, went even a step further and said, yeah, not only can the Medicare Advantage plan sue, but the people, the companies that are affiliated with them, called downstream entities, they can also sue for double damage, right? So it's serious business in Florida. I don't care if it's comp, liability, no fault. You got to be serious when you see that you have a Medicare Advantage claim as part of your file. Now that brings us to the question of, well, then how do we deal with this? Do you go to BCRC and CRC and ask them for a Medicare Advantage lien? No, they don't have it. Okay, you can write to them every hour and ask them for a Medicare Advantage lien. They don't have the info. Or I had a client out west one time call me up, great lawyer out there. She said to me, Mark, I don't get it. I asked your company twice to go to CMS and see if they had a Medicare lien. And each time it comes back zero. But that can't be, because the lady testified at the depot that both surgeries were performed by Medicare. So you know what that means, Heather? It means she's on a Medicare Advantage plan. Your government was right. CRC, BCRC is telling her zero because she wasn't in the governmental plan. She did discovery, found out it was Kaiser, or one of the plans out in California, wrote to them. Sure enough, they had a lien. So you have to be thinking this way. It's a different set of protocol, at least for now, okay? And will be going in the future. you go to the contractor Sid talked about, BCRC, CRC, for the governmental side of things. But when we learn that our claimant is involved in Medicare Advantage Plan, you don't go to BCRC and CRC. You have to go to the actual plan and ask if they have any sort of lien. Okay, so let's go to the next slide. Okay, maybe stuck again. No, here we go. So here's how, in a very thumbnail sense, we could talk about this offline if you want to buzz me more, but just very surfacely, to deal with Medicare Advantage liens, we already know how to deal with the governmental liens, right? The 111 is sort of connected there. You know, Sid talked about the ORM triggering CRC and BCRC, but you could also write to them, okay, to see if there's liens. But Medicare Advantage, different. So first you got to figure out whether the person is on Medicare Advantage, right? Okay. And as we sit here today, currently there is not a centralized way to do that. There will be come this December, more on that in a minute. Okay. So right now, the only way you know when you find out, yes, the person's on Medicare, the next question is, well, what type? And the only way to know that right now, the type, is to ask. Okay, whether in litigation will be discovery, whatever allowed, or part of the claims process, is to ask what type of Medicare does the person have. Now, also keep in mind that parties can switch their Medicare beneficiaries can switch their plans once a year, right? Sometimes more than that, okay? And so you could have a claim where the claimant was in and out of different plans. They were in the government plan for a little while, then they went to a Medicare Advantage plan, maybe they went back to the government. So you got to sort all this out through discovery, okay? And you got to figure out in the middle bullet, bubble, how's it going to be addressed? Who's addressing it? Who's going to the Medicare Advantage plan to see if they have a lien? Who's going to negotiate it out? Sid told you how it works on the governmental side, and you may have to do that too. Person could have been nuts. Was in plans every year for, you know, the 7 years of the claim, right? And you got all these different liens going on, right? And then, of course, settlement language, memorializing how it's all going to be done. Now, the big problem right now, okay, think about what's going on. You got Medicare Advantage plans suing for double damages and winning. There was a lot of red on that map, and there was a lot of yellow on that map. And I bet next year, if we do this, there'll be more yellow or more red on that map every year. You know, it gets colored in more, okay, because they're winning. But a big problem is identification. How can we know in a more proactive way, in an earlier way, other than discovery with the claimant? Claimant hasn't responded. Plaintiff lawyer is objective, okay? Having trouble figuring out what type of Medicare this person has. And with the double damages out there, right, the lawsuits being successful, people took it to the street up to Washington and said, we got to come up with a new law that makes this easier for us to identify the type of Medicare the person has. Sid, enter the PAID Act. Provide information directly Act. How will this change things? Let's look at the next slide. All right. PAID Act got passed around Christmas time last year. CMS is in the process of implementing it. More on that in a minute. Look on the left for me first. Underneath the PAID Act, technically the Act, let's read it together, requires CMS to provide the insurers through the Section 111 process the name and address of any Medicare Advantage plan and any Medicare prescription drug plan in which the claimant is enrolled or has been enrolled during the preceding 3 years. That's huge. That takes away a lot of the problems we have right now. Going to the claimant, production requests, discovery, depots, all types of stuff, right? Well, the PAID Act tells us that CMS has to give us the name and address of the plan. But go to the right. CMS, check this out. In a rare instance of them going the extra mile, right? Check it out. CMS is actually going to be providing more information for you. Check it out. They're going to provide, regarding the Part D and Part D's prescription drugs, in Part C Medicare Advantage plans, the contract number, the contract name, the plan number, the coordination of benefits address and entitlement date for the last 3 years. It's a lot more than the left box said, up to 12 instances, okay? They're also going to provide, check it out, the most recent A and B entitlement date. It's all there. It's going to be. It goes live. Look at the bottom of the screen. December 11th, 2021. Okay, this is coming to a theater near you soon. Okay, and it'll be coming through the Section 111 query. Look, Sid and I got a bunch of articles out there on this stuff. Okay, we're about to write another one this afternoon. CMS just had a webinar on their PAID Act. Okay, you want it? Give us a day or two. It's in the works as we speak right now. Okay, we have lots of materials on the PAID Act for you. Now, study the slide, study the green. So what we're saying here is, come December of this year, the Section 111 query is going to provide us with a lot of information about claimants who are enrolled in the Medicare Advantage Plans and or the prescription drug plans. And check the bottom out. They're even going to give us info about the Part A and B plan. It's all at your fingertips. So the question for you with respect to Medicare Advantage and Part D plans on the next slide is, what are you going to do with it? Okay? It's all there now. All right? Who's going to take the lead if it comes back through the query that Joe Smith is enrolled in a Medicare Advantage plan? It's Humana. Here's their address. Here's the plan number. Here's the plan name. Here's the coordination of benefits address. Who's going to take the lead to flag down a potential recovery lien, and who's going to take the lead in addressing it and resolving it? Okay, now, to be honest, and you see this in the article, you know, the PAID Act doesn't say the insurer has to do that. All the info's here, okay? You will now have that info. You will have to make this decision through the query. You're going to have it in December. Who takes the lead? All right, and this is what the PAID Act was designed, because carriers will get an ambush. They didn't know. Next thing you know, they get sued for double damages. They now know. They have the info. It's just a matter of who's now going to take the info, go to the plan, and ask if they have a lien and resolve it. This is something that needs to be decided as part of protocol come December. I mean, it needs to be done now, right? But this PAID Act is going to make it easier for you. Sid, I'm not sure you have anything to add to that before we go to Q&A, but that's my take so far.
No, I think you covered it. You know, I think you covered it great. So yeah, just you know, figure out what you want to do with the data that Medicare is providing, how you might want to integrate that within your Section 111 reporting already, how that intersects with your processes that you have. I think it's also a good time right now to reevaluate, you know, your process for handling Medicare Advantage plans. Mark already mentioned, you know, Florida type cases, high scrutiny based off the court decision. So yeah, now's a good time to take a look at it before this is implemented.
All right, Mandy, Diane, I think we have some questions. Oh, there it is. So let me finish it up right here. This is basically it. Look, PAID Act takeaways, how are you going to handle it? You may go different ways between the Medicare Advantage plans and Part D. That will be up to you. We're available. Just come to Sid and I. We'll help walk you through, you know, the processing. Sorry, Mandy, come back on. I didn't mean to scare you away. Okay. Oh, there's Diane. Okay, great. All right. Looks like the Brady Bunch here. Okay, yes, there we go. Go ahead. Yeah.
Jeremy, are you going to join us too?
Oh, hope we didn't scare him.
I am coming on.
All right. So Jeremy and Mandy, do you guys have some questions for Sid and Mark?
I did see some come through. Let me check the chat here. All right, let's see. Looks like this first question is about denied work comp claims and liens. Sid, this might be a good one for you. Okay.
Sure.
I think maybe if you can just kind of tell us generally how the lien aspect works with denied, you know, work comp cases, that would probably be good.
Yeah, if it's a denied claim, you know, again, you kind of have to look at both your Section 111 reporting and the recovery side of things, right? So on the Section 111 side, you shouldn't be reporting necessarily ORM, right? Unless you are accepting responsibility for ongoing medicals. And typically speaking, workers' compensation claims, you're not. So you know, if that's indicated as no, you're likely not going to get a CRC lien, you know, asking for recovery. But, you know, if you're settling the claim, you're looking to button that up, probably want to reach out to the CRC, make sure that, you know, if they have anything that's out there, you can properly dispute it. You can generally argue that the claim is denied, and therefore you wouldn't be responsible as the primary payer for it, and hopefully get the CRC to issue a case closure letter. Now, just be aware of that debtor switch, right? Because this is the prime situation where you would see that, where got a denied claim, you've disputed everything, CRC closes their claim, and then Medicare gets notice of the settlement, right? Again, through Section 111 reporting, through TPOC, and even though it's denied, you're still reporting ICD codes for that TPOC for any injuries that you are essentially resolving, you know, alleged or resolved as part of the settlement itself. So the BCRC may very well open a separate recovery claim for that, and you just want to be prepared for it. At that time, the BCRC is probably less likely to accept a dispute based on the fact it was denied, because they're, again, looking to pursue directly against the settlement. So just be prepared for who's going to take responsibility for disputing that or arguing that or resolving that. You know, and hopefully, you know, proper steps can be taken to resolve that. But that can happen for denied claims.
That's great.
We have a few more. We'll go through several. If we have additional, I took down your name, and we will get back to you with an email. Either Sid or Mark will get back to you. There was one here that says, can you challenge a Medicare recovery claim based on the fact that claimant went to an unauthorized doctor?
Yeah, great question as well. I could take this one. I mean, this is you know, more of a practice question. So yeah, you can still dispute that. I think the key in disputing recovery charges based off of that argument is to outline it clearly for the contractor, right? They're not necessarily well equipped to understand unauthorized, you know, provider, unauthorized treating physician in the context of conditional payment recovery. But to the extent, like, you know, your state statutes, or there's something that indicates, legally speaking, if treatment is administered or recommended through the unauthorized provider, you can utilize that to dispute conditional payments. And we've been able to do that successfully here at ISO Claims Partners. But again, you got to be cognizant of the evidence that you're providing, making sure you line it up simply, and try to persuade the contractor to understand it.
Thank you.
Great, thank you, Sid. Next question, probably this is you, Mark. What is the main point about the PAID Act that you think we should concentrate on?
Oh yeah, I was pretty passionate about it before. I think you now are going to have the information to know, okay, a lot earlier than you ever did before. What are you going to do with it? Because you really could be in the driver's seat if you take that information and come up with a plan to make sure these plans are addressed.
Here's another one. We have like two more. I'll let Jeremy take the last one, but this one here is, how about Medicare on the check?
I can try to take this one. So I assume you're talking about where you're putting Medicare on the settlement check versus just paying Medicare as part of a conditional payment, right? So obviously, if you're paying Medicare, then you would, you know, make payment in accordance with the directions that are listed on the letter, making sure that you indicate the case ID number and the individual that you're that it's being paid off for as far as the Medicare debt itself. But if you're, you know, I think this happens in liability claims where, you know, the parties might just write Medicare on the settlement check, thinking that, you know, that's sufficient to consider and protect Medicare's interest with respect to conditional payment recovery, especially if, you know, the requirement through, you know, the settlement contracts or whatever is written that the plaintiff or the plaintiff's attorney is going to be resolving and handling conditional payments. Now, you know, we've seen that happen, I think, a couple times in some of the court cases that Mark can probably talk to, but it's been determined that that's not going to be effective, right? That Medicare is, one, not a party to the settlement itself. They're not subject to, you know, the terms of that. Just because you're placing Medicare on the check doesn't necessarily absolve you of the responsibility to make payment as a primary payer, and Medicare can still very well enforce their rights, their statutory rights to pursue any party that makes or receives payment. So I'd be very careful about just simply putting Medicare on the check and thinking that, you know, that's going to protect me should that debt not get fully paid or resolved. Mark, do you have any additional information? I guess you're better on the court cases and how that's kind of effectuated through that.
Yeah, I agree. Everything Sid really nailed it from a practice standpoint. Look, there's no requirement in statute that Medicare be on the check. The court's pretty clear about that. It also, if it's a practice that you think is a wise thing to do in your case, you better make sure all the parties agree to it. There was a case many years ago, Tomlinson versus Landers out of Florida, where liability case, they settled the case very similar to what Sid said. There was no discussion about Medicare being on the check. You know, it was about who's going to take care of Medicare. And then when the settlement documents arrived, here came Medicare, the check. And the plaintiff was very successful in saying to the court, that's not what we agreed to. All right. So if that's the way you want to go, whether it's wise or not, it's a whole other issue. You better make sure people are all in agreement on it.
Mm-hmm. Sounds good. I think we bumped up right against 3 o'clock here. There are a few more, but as Mandy mentioned, we'll have Mark and Sid reach out directly to those of you with additional questions. So I'd like to turn it back over to Diane.
All right, everybody. Well, we'd like to thank you again for joining us today for the Macro Pro webinar series. We do provide educational programming for our clients and potential clients. If you have any questions about our services, please feel free to reach out to Mandy or myself. The emails for us are really easy. It's mandy@macropro.com, MACROPRO.com, and Diane, DIANN@macropro.com. You will be receiving your certificates today via the email, so please look out for that. We do appreciate you joining us, and you have a wonderful day. Thank you, everybody, and thank you to all of our experts. Experts, please look at the camera. We'll take we'll do a screenshot. All right, we'll take that. We'll place that on the MacroPro website. We will talk to all of you later. Bye-bye now.
Bye.
Bye. Have a great day.